My name is Stephen Harris. I've been a lawyer here in Charleston since '05. I started my career as a public defender at the public defender's office downtown, where I was a public defender for 3 years. I do criminal and civil litigation. I do about 5% civil litigation, so about 95% of my practice has been criminal defense for the last 12 years. So I know a lot about guns and gun law, because as a public defender and a federal I did work as a federal appointed CJA panel lawyer for the last 12 years also. You get a lot of federal gun cases, and the federal laws with guns really, I think I may have gone over some of them earlier. You know, if you're a felon with a firearm in South Carolina or anywhere in the United States, it's a 5-year mandatory minimum. If you're a armed career criminal, it's a 15-year mandatory minimum if you're a felon with a firearm. So I've gotten to know my firearm practice fairly well over the last 12 years, because it's an ever-evolving law. The firearm laws in South Carolina are evolving every day. There's new bills that go up for, you know, we had a bill go up 2 years ago. It didn't pass, but to make it where we were almost as close to an open carry state as you can be, but it didn't go through. You know, with the guns in bars, you know, a lot of different places where you can carry concealed weapons, those have changed recently, but I think y'all may have gone over some of them earlier. Today I'm going to focus on self-defense, castle doctrine, and the confusion people have with stand your ground and duty to retreat. And a lot of people, and we'll go over it in a little while, when you're talking about self-defense and castle doctrine, a lot of people will argue that self-defense and castle doctrine are the same thing. They're not. And they'll argue that stand your ground is castle doctrine, and it's not. You get, I'll bring up some examples in a little while of a case I specifically am working right now, where I got, you know, almost attacked by the National Action Network because I was arguing castle doctrine in a murder case, and every time they'd go on the news, they'd bring up stand your ground and say, this isn't a stand your ground case. This is not a Trayvon Martin case. This is a different kind of case. I don't know why he's arguing. And I never used the word stand your ground once, but the news went with it because it's a confusing topic, and if you're a practicing lawyer, I'm hoping to clear some of those up today, because there is very distinct differences. All right, I just went backwards, didn't I? Okay. Yeah, and also I am a trial lawyer first and foremost, so presenting this way is not the way I do things. So I apologize in advance, because I don't go off slides usually when I'm doing things. I walk around and use my hands a lot and I talk a lot. So today I'm hoping we can do that, and that I'm hoping it can be interactive and people can ask questions. I grew up in Mississippi. I've been here, like I said, for 15 years. Grew up around a lot of hunters. I wasn't necessarily a hunter myself. I tried it a couple times, and being in the cold at 3 o'clock in the morning with a cold gun in your hand just didn't seem like the right thing for me to do, because it seemed a little contradictory. But so first gun I ever had was a 20 gauge shotgun when I was about 15 years old. My dad bought me that to go hunting. My dad later sold it about a year later because I never used it. I'm telling you about guns today because, like I said, I practice in this field. I am a gun owner. I'm not a CWP carrier, but I do own 3 different firearms. I defend a lot of people that are charged with either unlawful carrying or carrying by a person that's not permitted, like a felon, or somebody that's had a domestic violence charge in the past. Have y'all gone over that today about what CDVs do to gun ownership?
No, we did not.
Okay. Does anybody know what a domestic violence charge does to gun ownership? Okay, domestic violence, I'll hit this because this is an important one too for practicing lawyers. Domestic violence is a 30-day offense. The way it's written in South Carolina, the law, it triggers the Federal Gun Control Act, which means if you're convicted of a 30-day misdemeanor, which any other 30-day misdemeanor does not trigger that, but if you're convicted of that 30-day misdemeanor, you lose any and all rights to own a firearm. Purchase, own, anything, because the federal government's law specifically says domestic violence. In a lot of places, a domestic violence charge is a little higher than in our state, but our state's 0 to 30 on a CDV first. There's also other laws that will trigger the Federal Firearms Act, and if we have time, I will go over those, because it's important when you're advising your client on pleas. By the way, anybody here do criminal defense? Okay, so when you're advising your clients on accepting a plea, on accepting things, there's certain laws and certain parts of the law that trigger the Gun Control Act that a lot of people don't realize. For instance, with CDVs, if you plead your client from CDV down to simple assault, which is not a Federal Gun Control Act charge, you still lose your rights to own a firearm, because it initiated as a CDV, the factual basis is a CDV, federal government sees it as, just because you pled to something different, the facts of an assault and a CDV do not change, except that one is a domestic partner in your home and one is just, could be anybody. But it doesn't change, so your client's still going to lose the rights to firearms. And I know that because one of mine specifically did, because he wouldn't listen to me. He didn't believe me, and 6 months later the federal government sent him a letter saying, lose all your guns. But that's what I do. Like I said, I'm a practicing criminal defense lawyer. I deal with a lot of the unlawful carrying charges here. And it's like I said, I haven't looked at everybody else's presentation, so I don't know what you've been told already regarding like laws and where you can carry guns and things like that. And we'll touch on those in a few minutes. Let's see. All right. Concealed carry. The definition of concealed is it carried in a manner that's hidden from public view in normal wearing of clothing. That means you can wear it here, you can wear it here. I mean, as long as it's concealed from somebody, you cannot wear it sitting in a holster on your hip, like a cop or like a cowboy. That's open carry. Concealed is, it's somewhere where the public cannot see it. So, have y'all gone over concealed weapons today? Again, I'm just asking because I don't want to reinvent the wheel. Purse, briefcase is okay, but, you know, again, this is kind of a joke that I've had questions about fanny packs and men's carrying bags. I would assume it's okay. I hadn't had that case come up, but it's still concealed. So as long as it's not seen from the public, as long as it's not sticking out, you're okay. Firearms less than 12 inches in total length, and that 12 inches is important because it's less than 12 inches. It's not 12, you know, it's not over 12 inches is illegal. It's less than 12. The statute only talks about the concealed weapons, only talks about firearms. It doesn't talk about other weapons like knives, anything like that. So it's specific to firearms. And basically you can have any pistol that's smaller than 12 inches, you can carry it. And then we come to why I mentioned that, because Dirty Harry had a .44 Magnum. It was 12 inches in length. You know, who saw Dirty Harry? Anybody? Remember the gun that Dirty Harry had? All right. It was 12 inches, exactly. So Dirty Harry couldn't carry his gun in the state of South Carolina. I don't know how you'd conceal it to start with, but I mean, I guess he concealed it in here, but you could not carry that gun in South Carolina because it is exactly 12 inches. It has to be less than 12 inches, and that's very important because there are a lot of guns that are 12 inches exact.
Could he carry it as a police officer from somewhere else, because he was a police officer?
Well, police officers, the concealed weapons carry, if you're on active duty, CWPs don't apply to police officers.
That's my question.
Yeah.
He was a California police officer.
Right.
He came here and he was on the job.
If he's on the job, yes. But if he was just here and that was his favorite gun and he brought it with him in his suitcase, no, not vacationing and not to go eat down on King Street. He could not have a 12-inch .44 Magnum. So, but a police officer, you know, gun laws don't apply to police officers. They, you know, and obviously they have open carry. South Carolina doesn't have open carry. There's a few states in the Midwest and throughout the country that do have literal open carry. You'll see them on the news. Anytime a gun law looks like it's going to get changed, or a politician looks like they're going to change and take away our guns or give us more guns, whatever you may think, that's when you find out what states have open carry, because that's when the people in those states walk around with AR-15s. I don't know if y'all have seen those where they're protesting. For instance, I think Arizona was protesting when they thought Hillary Clinton was going to come in, and they all walked around with AR-15s strapped on their back because you can do it there. But
when you say open carry, it's the guy at the liquor store that always has a sign on. Is there a permit you get for that?
That's different. That you can open carry in your house or your business if you're the owner of the business. So there's carrying a firearm with concealed weapons permit or with anything, like if you're in your home, you can wear a sidearm all day long. You have to have that license, but because that's his business and he's the owner of that business, he can't, I mean, it's hard to delegate to tell somebody else, oh, well, everybody in my business can carry guns. It doesn't work that way. But if you're the owner of that business, and especially if it's kind of like a banker could do it if they technically wanted, or the owner of a bank could carry open. Inside the bank, but not outside. So I think we may get into that on here. I can't remember. I did a presentation on gun law, and again, I apologize. I did a presentation on gun law, and we did the entire gun law, and then I had to pare this down. So I'm going off again. I'm trying to get this part in because this is one other one we have a lot of questions on when I deal with gun CLEs, is concealed weapons permits. And so I put this at the beginning of because concealed weapons directly correlate, in my opinion, to self-defense. Because why else would you carry a gun unless you were trying to defend yourself? I'm hoping that people don't have a CWP just because they think it's fun to say, I got a gun on me.
But you know that's true.
It probably is. There's probably 10%. but you still must be 21 years old to carry a gun with a CWP. An 18-year-old can, the laws are so weird, and we'll get into them in a minute, but you have to be 21 years old to carry. You can buy at 18. You cannot buy certain ammunitions. You literally have to walk in. It's to a point where you have to walk into a Field and Stream type store if you're 18 to 21 years old, or 18 to 20 years old, and say, what can I do? Because the laws are strange. They just make it where they're almost contradictory to each other. Make it where you can possess a gun, but you can't possess the bullets, or you can't buy the bullets. So, all right. You have to be a resident of South Carolina or a qualified non-resident, which means, if you're here under certain restrictions, under certain qualifications, you can qualify to get a concealed weapons permit in South Carolina. I'm not going to get into all those because that's way deep into the weeds on what we're talking about today. You have to be 21 years old, no physical infirmity, which would prevent you from completing the range requirement, which if you've ever gotten a CWP or gone to one of the classes, the range requirement is laughable. You stand here and shoot at a target from here, and if you can hit it, I think 7 out of 10 times, you get a concealed weapons permit.
So they actually test you?
Yeah.
I don't know.
Oh yeah, you get tested. I saw a 75-year-old woman get one at Limehouse over in Johns Island, and they gave her a 22 that was about this big. I mean, it was literally one of those little 22s, and she sat there and squeezed it and hit 7 times, and now she's probably 80 and carrying a firearm.
And how big is the target?
It's pretty big. I mean,
You just have to hit the target?
You just have to hit the target.
Anyway.
Not on the outside where the circles aren't, but you just have to make sure you're in that big circle right there. I think it varies. I mean, there's certain places like I said, RPM and Limehouse on Johns Island, where all us good old boys live. If you go in and pay for the class, you're walking out with a CWP pretty much. So there's some people that are going to be a lot more strict about it, but like I said, I don't have mine, but I have seen, I've gone to the classes because there's a CLE I go to every year on gun law, and you can get your CWP by staying the extra 5 hours for that, and I did it just because I wanted to see what it was all about. So, but there is no other restriction from owning or possessing, and here we go. It's an 8-hour class with a photo ID. Oh, it's 50 rounds at a target with a 70% hit rate, not 7 out of 10. I'm sorry, it's a 70% hit rate. You get 50 shots to try to hit the target with a 70% hit rate. Fingerprints are sled to make sure you don't have any criminal background. And I know that's a big point of contention for a lot of people because that's another issue that comes up yearly with, are the background checks too lenient? Are they too stiff? It depends on who you're talking to. NRA says they're too stiff already. Everybody else says, what about Dylan Roof? What about all these people that got guns that probably shouldn't have had them or definitely shouldn't have had them? Because, technically in our state, if you've got a drug charge pending, this is another one that a lot of people don't know. If you're arrested for drugs, you are prohibited from buying a firearm for 6 months. Depends on the drug, actually. With cocaine, I believe it's a year. But with marijuana, it's 6 months. And that's another one I learned the hard way, because one of my clients, I had an ATF agent call me and say, hey, your guy just went and bought a gun at a pawn shop down here, and they ran everything, but we didn't get back to him in time that said that he had a pending marijuana charge. He can't buy a gun for 6 months. Can you tell him nicely to bring it back? And I said, I'll try. And I never found him, and he got rearrested on something else, but that's beside the point. Yeah, this is just info on the statutory and case law of South Carolina. This is what you learn in the class. You learn basically a brief synopsis of what you're learning today, and then you learn handgun safety, proper storage, and then you fire the handgun with the instructor. So that's basically what you do if you wanted to go get your CWP.
Do you have to have a handgun to get it, or do you get your permit and then get it?
I think it depends on where you go. I think you can use one there. Most of them take place at gun ranges or gun shops, and you can rent a gun there. You go to Quick Shot, they've got almost every type of gun you can rent. They've even got, because they're having FFL, you can go to Quick Shot and shoot a machine gun. Again, I know that because I've had a guy sitting next to me. These two tourists were sitting next to me, and they probably shot $4,000 worth of machine guns in 2 hours. And literally, it was like all you heard was rapid fire right in the stall right next to me. So it was a little bit annoying. Oh yeah, that's another one about carrying your CWP. The statute seems to say that you have to, like some people ask, well, if I have one, it's in the system, do I have to have the actual with me? And the answer looks like is yes. It's not there's nothing in there that says, if you do not carry it on you, you're going to go to jail or you're going to be charged with unlawful carrying. I keep talking about unlawful carrying. Does everybody know the difference in unlawful carrying and carrying a firearm? Where you can carry a gun if you have one? Even if you don't have a concealed weapons permit.
I thought at one time it was like a glove box.
It's a latched glove box or console. It's not locked. That's a big misconception a lot of people have. Some of the older cars had the key that you put in and you could lock your glove box. I don't know if newer cars have that or not, but I remember. Yeah, but you do not have to have it locked. That was a misconception a lot of people had that said, because it's latched. So it has to have a latch. It can't be, some of these you can just like lift it up, or it's just a hole sitting there in your console, where you can just reach down in and grab or put a soft drink or something. You can't put it in there. You have to have a latched glove box or your trunk. So you can't carry it on your person in your car. You can't, go ahead.
This is if you don't have a CWP.
This is if you don't have a CWP.
You can keep it in your glove box
Uh-huh.
or in your trunk.
Yes.
Okay.
Yeah, or in your console if it's got one of those latches. Or, for instance, if you have a biometric safe or something. I have a friend that has a biometric safe in his car, and it pushes and it pops the thing open. That's legal too, because that's locked. You just can't have it out in the open where you could reach and grab for it. You have to, I guess they're saying you have to make that extra step, open the glove box. So, but that's why when I keep saying unlawful carrying, unlawful carrying is a 0 to 1 year misdemeanor in the state of South Carolina. And it's referring to if you have it on your person and you don't have a concealed weapons permit, or if you have it in your car, let's say on the floor, underneath the seat, in the back seat, anywhere that's not a latched glove box or trunk. So,
Unless they don't have a trunk,
right.
pick up where you would customarily carry it.
In a pickup truck?
Yeah.
Glove box, or, if they have it, do you have a glove box in it? Most of them have glove.
If you have a lawn or whatever, it doesn't have to be.
Oh, no, I'm talking about pistols. I'm talking about concealable weapons. I'm not talking about long guns. I'm talking about, long guns and hunting guns are under a different statute. This is anything under 12 inches in length that's a concealable firearm, is what I'm talking about on that one. And I was only clarifying that because I keep saying it. And again, not everybody in here does criminal defense. If you do criminal defense, you know what an unlawful carrying of a firearm is. But if you don't, then I'm just sitting here saying it, and I don't want to have blank stares. So, go ahead.
I have a really dumb question. So then if there's special considerations, then all the shows you see on TV with gun racks in the back of a pickup truck, I take it those are illegal. in South Carolina.
No, gun racks are not, I don't believe gun racks are illegal in South Carolina. Like I said, that's a long gun.
Oh, a long gun.
A long gun is different. A long gun has different rules on everything. You can go, like, long guns, the rule to buy them is different, the waiting period's different, and I'm assuming, I didn't read the legislative intent on it, but I'm assuming it's because they're not concealable. That's why sawed-off shotguns are illegal, because they are concealable, because you can buy a long gun. I don't think you can buy them at Walmart anymore, but you used to be able to walk into Walmart and buy a shotgun or a rifle that you could put in the back of your truck. So there's different rules on that, different laws. So what was your question?
The reciprocity with other states, and your experience where you found that you have a locked glove box and you pull over, say, North Carolina.
My suggestion is if you're transporting a firearm, check the state you're going into, because they're not nice about it. They don't give you the, oh, well, you didn't know. You know, ignorance of the law is not a defense.
It used to be that they did have some
Right.
reciprocity. I just didn't know
And
the local trend.
the CWP reciprocity is even stranger. That's why a lot of people are trying to push for a national concealed weapons permit as opposed to a state by state, because the laws differ so greatly that you can be driving with your legal firearm on you and go through South Carolina, North Carolina, and then all of a sudden hit another state, and in that state, what you're doing is 100% illegal. It's a felony. You go to New Jersey, for instance, and talking about guns in New Jersey is a crime, basically. I mean, the laws up there are strict.
But talking about this,
No, I'm exaggerating, but I mean, there was a woman that had a firearm that was in her glove box, and she's from New York and drove into New Jersey and got pulled over, and it made national news. She was looking at 3 years in prison, and she was a single mother and just happened to leave her gun in her glove box. Well, New Jersey, she wasn't doing anything wrong. They just said, you know, this is a 3-year mandatory minimum on this case. And luckily, I believe Chris Christie either gave her clemency or something. Something happened with it, because she was literally going to go to prison for 3 years for carrying a 100% legal firearm that in, I believe the state of New York, is registered firearm. Here we don't have to register them. You hear the term registered firearms? Everybody hears that? And you say, well, you know, there's no such thing in South Carolina as a registered firearm. You can buy a gun from anybody. I had an AR-15 made and bought it with parts, and as far as now this class knows that I have it, but other than that, I mean, the federal government knows that those parts were sold, but they don't know. Actually, the federal government only knows that one part was sold, because there's only one part that's covered by the ATF. But there is no such thing as a gun registry in South Carolina. So when you hear people saying, well, is it a registered gun? The only thing that registers it would be if you went to Field and Stream over here and they ran your background, they've got you in the computer that you bought a gun. So that's another misnomer, I guess, is you hear a lot of the gun registry. So, yeah, and again, the rule is if you've got a gun on you and you're carrying and the cops come up and they stop you, this is again, you have to look at which law you're following. If your gun's in your glove box, you don't have to tell the police your gun's in your glove box. If you're a CWP holder and you're carrying it not in your glove box, you have to tell the police and show them your CWP with your gun. So if it's in there, you don't have to tell them. And that's any of us. We can carry a gun in our glove box and don't have to tell the police when they pull us over. But if you're carrying it on you, then you have to tell the police and show them your CWP. Again, so reach for it slowly too. So, you know, that's just place you can't carry. Obviously, businesses that sell alcohol and drink when you're drinking, the jail, courthouse, polling places on election day, office, business meeting place of governing body. This is again public county buildings and things like that. You just you can't carry around a concealed weapon on those places. Some more you can't do it. School or college athletic event, not related to firearms. Again, if it's a shooting event and you're a pentathlete or whatever the shooting sport is, then you can have one. Daycare facility, preschool, thank God. Places prohibited by federal, state, and hospital and doctor's offices. But ironically, at hospital and doctor's offices, doctors are usually authorized to carry, or they can be authorized to carry a gun. But None of us could carry one if we had a CWP. Go ahead.
But they could carry it
A
as
doctor,
the owner of the business.
yes.
Without any.
Like if you're a doctor and you are carrying a concealed carrier and you have an office, let's say on the campus of a hospital, and you have privilege at that hospital, if they tell you it's okay, you can do it. It's not statutorily barred.
Okay, thank you.
Place clearly marked with that sign. Do you remember? I guess it's about 4 or 5 years ago, they started talking about when they passed the concealed law about carrying it into places. They said if there's a specific sign that a business has to have, and if they have it, you cannot bring a gun in there no matter what. Post offices, Capitol grounds, obviously. Banks are actually okay, but unless they have that sign. Which,
Convention center? They have a
yeah,
sign
I mean,
up there that says-
yeah, if the convention center says no, then no. This is what I was talking about. This is the people that can carry without a CWP. If you're a business owner and you own that business and you're in your building, there's question marks if you're renting. Because if the owner of that complex and you're in office, you have an office in that complex, the owner says no, you can't. But if you're the business owner and you own that property, then yes. And that's why you see liquor store owners carrying guns. Managers, employees who have permission, there are certain rules, and I'm, again, not trying to get into the weeds, there are certain rules that say you can't just say all my employees can carry guns. Everything from dishwasher to the manager of the place, because it's just, there's certain rules you have to follow. And that's when you would need to, if you're a business owner and you wanted to do that, that's when you would need to contact SLED or contact ATF and find out what you need to do. Okay. Other people's homes, you have to have their express consent. So you can't, again, I've had cases where clients go into his friend's house, cops stop them, and he's got a gun, and he's like, well, I'm going into my friend's house. Well, unless he can show he had express consent from the homeowner, specifically the person that, is living there, then, or that lives there or owns the place, then you can't just say, oh, I was just carrying it in here. I can legally carry it inside that house and to that house.
Question.
Sure.
Tenant.
Mm-hmm.
May a tenant who rents an apartment from a landlord have a gun in that area, in that unit, without the permission of the landlord?
Unless the landlord specifically says no, yes.
Thank you.
A landlord would specifically need to say no, because when you rent someplace, under the laws, that's as if that's your home, that's your domicile. So therefore, when you're the tenant there and you're renting, if the landlord says no, if it's in your lease, no guns in the house, then obviously, you can't have guns in the house because you don't have the express consent.
Is it a constitutional violation to regulate what somebody can keep in their home? Even if they rent it, they specifically own that for that tenancy, that period of tenancy. Is that some sort of, it seems like that would be a violation to take someone's rights away from owning a gun in their own home. Even though it's technically a rental.
Yeah.
It's theirs for the purposes of the tenancy.
It's a matter of contract law, then, right?
It's a matter of contract.
Yeah, I mean, that's what I'm saying.
So you can weigh that under contract.
Right. I mean, your choice is then don't rent the place. Yeah. I mean, they couldn't come to you if you had a 5-year lease, day 2, and go, by the way, no guns, dogs, or kids, because, then you got a pretty good case. But I'm pretty sure that, because it's again, contract, I mean, if the cops came in and you're the legal tenant there, I don't think they can arrest you based on that person's contract with you. That person could probably evict you.
Right, okay. So
But
there is a
I think
contract.
you'd be okay under the law, the more I think about that. Like I said, that's never come up for me as a question. That's one I'd have to kind of look deeper into. But you'd think logistically that it is your place. And, the police can't come in without your permission. They can't come in with the landlord's permission.
Right.
They can't come in without yours. So I would guess that they wouldn't arrest you for having a gun in there unless you're a felon.
So I wonder if it'd be an unenforceable clause of the contract. That's interesting. I don't know. it's just
Yeah,
something about-
it might be. I don't know. Like I said, if and when it comes up, if I ever litigate it, I'll let you know.
Maybe if I need to hire you.
Yeah. Okay, so when you just bought your first handgun and you don't have a CWP, and here's the question is, can you carry it in your house or in your car without a CWP? And the answer is yes. in your house, yes, in your car, in the glove box, but not, again, not in the,
But you're walking from the car to the house.
if it's in a box and you're walking from the store to your car, or you're walking from the car to your home, it's considered, that's legal.
Okay,
But if you say I'm walking to my house and you go down to the bar and have a drink and then you go somewhere else, and you can't say, oh, I was just carrying it to my house, I just had 3 errands to run. It's, because if you couldn't, then you wouldn't be able to buy a gun at Field and Stream, because you'd walk out to your car and the cops would be sitting there every time saying you're openly carrying a firearm. Special privileges for CWP holders, most judges, prosecutors, assistant prosecutors, and anybody that's in law enforcement that's not a cop pretty much has some special privileges when it comes to CWPs.
did you have that when you were a public defender?
No, they don't want us doing anything as public defenders. Public defenders don't get any special treatment. They actually get worse than special treatment. No, but prosecutors, I know, the ones I knew, they used to give prosecutors a badge and make them get a CWP. I don't know if they do it anymore. Anybody here was a prosecutor? Did they make it?
I was, you didn't have to get up to CWP, you did get a badge, and you did carry the courthouse if you choose, and I have carried in the courthouse before.
Okay. Yeah, I just wasn't sure. I know they used to do it, and then,
Without a weapons permit.
yeah,
As long
that's
as you're on the job.
right.
You don't need a concealed weapons permit to carry concealed.
Right. That's those special privileges for, I know Ralph Hoisington used to make people get a CWP just to kind of double it up, but they technically didn't have to, because if you have your badge and you're a prosecutor and you're in the courthouse, you have, legal right, special exemption, basically. Here goes the reciprocity question. I knew it was coming up. That's the CWP reciprocity we have with other states. Again, must know the rules of that state. So if you are going to another state and you want to take your gun with you, just learn the rules. Because, again, you can't carry in Georgia with a South Carolina license, and they border us. And, but in North Carolina, you can. So it just depends on who gives you reciprocity. How do you lose it? You either move out of state, you surrender it, or you're charged with a felony or other crime. Don't have to be convicted, just have to be charged. So that's how you lose a concealed weapons permit. It's not a right, it's a privilege type of thing. So it's not something that they have to give you back. So if you're charged with a felony. There is a list, but it's not available to the public. That's the one thing. The government does have the list they talk about, but you can't go. Like, for instance, I remember in New York, they wanted to release the list of who was carrying who had a CWP, so they could know, where they are in the state. And I know in South Carolina, we don't release that list. It's not made available to the public. I'm going to go through a couple of these quick, just because, again, this is not what I was really here for. This was something that, again, I have a lot of questions about, and this is rights under the Second Amendment, or, there are ways to carry guns under the Second Amendment. Handguns, you can't legally possess or carry a handgun openly or concealed unless you fall in the statutory exception. What are they? In your home, again, that's one we talked about earlier. You have the same rights even if you don't own the premise. This is what we're talking about, the lease. There we go. Can't carry in a common area of an apartment. Like if you're leasing an apartment and they've got a courtyard, you can't legally carry right there, because that's technically common area. It's shared by all the tenants. So that's not somewhere, because then you're infringing on them. That's considered public space. Can you shoot on your property as long as it's safe and legal to do so? If you're in the county, yes. If you're in the city, no. City's got, you have to look at what your ordinances are. We have a discharging a firearm ordinance in the city of Charleston. Can't shoot a gun in the city limits. I live on Johns Island, and my house is in the city, but my office is in the county, and I can shoot my gun at my office, but at my house I'd get arrested, and they're a quarter mile from each other. So you really have to know where you are. Foster homes, like I said, this is again, this is what I was talking about earlier. This is the unlawful carrying. It can be loaded. It's got to be in your glove box, console, or trunk. Closed and clasping. It doesn't need to lock. And it can be in a container too. It could be in a gun safe, for instance. So, what if you get pulled? This is a slide I stole from Ryan Schwartz. So, I don't always tell the officer I'm carrying, but you should always tell the officer where you're carrying, that you're carrying, and where the gun is. Being up front makes it honest and easy. I mean, obviously, if a police officer pulls you over and you don't tell them within the first 10 minutes that you have a firearm in your pocket, it's going to escalate things pretty quick, because telling them ahead of time is going to diffuse the situation. But when they find it in your pocket and you haven't told them yet, they're probably going to arrest you. So, or at least give you a hard time.
Even if you have a permit?
Mm-hmm.
They could arrest you?
That's why I said you need to show them your permit, and tell them where your gun is when they pull you over. It's just best practice.
Yeah, that just sounds like that.
And here's the what if you don't have a trunk question we asked earlier about the guns. Luggage department areas where the manufacturer designed luggage to be carried. Like if you have I know for instance, a friend of mine had a Corvette, and it only has 2 seats, and I believe you can carry it behind those seats where you traditionally would put luggage, because there was an open area, but behind the seat where you can't reach it is considered an okay area on that. There we go. Again, this is back to what I've talked about earlier. Motorcycles, without a CWP, you got to carry it in one of your saddlebags compartment that has a latch on it. Boats. Hunting and fishing. Obviously, if you're in a duck hunting boat and you've got guns open and obvious, that's an exception to a carry rule, because you're going there. I'm sorry?
Why would you need a gun for fishing?
Snakes.
I was just curious.
I carry a gun when I fish.
I'm not an official person.
Alligators.
Alligators and snakes.
Okay.
I used to fish in the Mississippi River, and snakes would fall out of the trees
Okay.
when you were going through the trees, so you'd have a pistol with rat shot in it. My cousin scared me to death because I thought he was going to put a hole in the boat one time when he shot a snake in the boat. But he didn't.
Thank you. Sorry to interrupt.
Sure. No, there's no interruptions. Like I said, I'd prefer question and answering and people learning something to me standing up here boring you to death with slides. So any question you have, please ask, because if it's okay, I'm going to skip forward to why I'm here. See, these are all the things I'm talking about. It's a misdemeanor to drink and shoot guns. So just letting you know, that's why the people are getting drunk and shooting guns in that picture. All right, self-defense. This is a big question that comes up a lot. It's come up a lot nationally in the last 10 years. We've had Michael Slager case, they're arguing police duty / self-defense. Trayvon Martin, they argued self-defense. They tend to make national news because the ones that are fringe make national news. The ones where it's, maybe the elements are there, maybe they're not clear. But a clear case of self-defense, you're not going to see many elements of, or you're not going to see many times on the news. Because, again, the 4 elements of self-defense, we'll go over these. You must be without fault in bringing on the violent encounter. And this is one of the most important ones that we run into, because if you're a lawyer and you've got a case where, let's say there's 2 drug dealers, or a drug dealer and a person, the person's selling drugs, and another person pulls a gun on them and they shoot that person, are they entitled to a self-defense? The answer is usually no, because you're committing technically a violent felony or a felony. You invited the danger by committing the crime. So therefore, even though you're the poor, harmless drug dealer, whatever you want to call him, had a gun pulled on him, he's probably not entitled to a self-defense argument. I mean, his lawyer's going to find a way to make the argument, but chances are you're going to fail because you were not without fault. And again, it's without fault. It's not, did you contribute a little bit? It's 0 fault. So that's another one you run into, because a lot of people say, well, he didn't technically contribute all of it, but a little bit, and drug dealing is a dangerous game. Chances are one person's going to have a gun, so therefore, you committed a crime, know or should have known there's going to be a gun involved, so you lose your argument there. Must actually believe you're in imminent danger or loss of life. One example used in a book that I'll tell you guys about in a little while is you got a person that says, an ex-boyfriend of your girlfriend calls you and says, you know, something to the effect of, I'm gonna, if I can't have her, you can't either. Nobody can. Well, they're on a telephone. You know, do you actually believe that person? You know, you don't know where they are. They're on the phone. They didn't say, like, I'm in your front yard, I'm going to shoot you right now. There's nothing imminent. There's nothing threatening. So it's not imminent. You're not in imminent danger. It kind of goes back to the assault. Is it assault if somebody calls you and says, I'm going to drive over tomorrow and I'm going to kick your ass? It's not an assault. That's not even a threat. That's nothing. But if I'm standing in front of you and say, I'm going to kill you, you're in imminent danger. If I feel like you've got the way to do it. I don't have to see the gun necessarily, but if you say, I got a gun, you know, like if you're in my face, you say, I've got a gun and I'm going to kill you, I actually believe I'm in imminent danger. I think most people would.
So it's actually not reasonably or rationally, or it's just actually.
Well, right, and everything's done on the reasonable person basis. So you look at it, because self-defense, unlike counsel doctrine, self-defense is a jury question. Self-defense is and we'll get into castle doctrine later. Castle doctrine is pretrial. It's a immunity from prosecution. Self-defense is not an immunity from prosecution. Self-defense is a legal argument that a jury asks the questions, or a jury has to answer that question. But self-defense, the prosecution has to show beyond a reasonable doubt that it was not self-defense. So that it's the one time usually, or basically in trial court, where you're passing the burden that's your burden usually over to the prosecutor to actually prove something. So, and use deadly force if here we go. Reasonable or prudent man or ordinary formist and courage would have believed himself to be in imminent danger or loss or serious bodily harm. That's what, again, that's the standard, the reasonable or prudent man standard, or woman standard, I guess you could say. And then the other one is, you had no other probable means of avoiding the danger of losing your own life or sustaining serious injury. This part right here, number 4, for some reason I have them all as number 1, but number 4, the common law was if there's no other probable means of avoiding the danger. That's that way in the common law of this and the common law of the castle doctrine. That's gone because of the stand your ground law, which we'll go into in a minute. Stand your ground law says, it used to say, if you can get away, you got to get away. That's what the 4th self-defense argument was and the 4th castle doctrine argument was. Now it says that there is no duty to retreat. The term stand your ground has been used regularly across the country. This is the Zimmerman case being the most prolific of these cases. Basically what it says is, if you aren't engaged in a line of activity and you're attacked, you can stand your ground and meet the attack with force, including deadly force. And we go into, if you reasonably believe that your force is necessary to protect you or someone else from death or great bodily injury or to prevent the commission of a violent crime. Again, your force is the necessary force. Okay, you have to believe that the force I'm using, because if somebody is just a slight bit bigger than you, your same age, and they're about to punch you, you can't pull a gun because you believe like, oh, he's going to beat me to death. That your force is not necessary at that point to protect yourself. If you're a 75-year-old man and the person attacking you is a 320-pound MMA fighter, deadly force may be necessary because there is a significant chance that person could beat you to death or could kill you with what they're doing or cause great bodily harm. So again, it goes back to the prudent person, reasonable prudent person standard. You just have to make sure that the force you're using is not significantly greater than the force used against you. And again, that's stand your ground. That's where, with the Trayvon Martin case, again, the force, that's why it was a big argument that this was not a stand your ground case, because the force used by George Zimmerman was a firearm. And the force used by Trayvon Martin was a pack of Skittles. So, or whatever it was. You know, that's why that was such a big controversy. That's why, again, that one made the national news. because that one did not have these 4 clear factors. You know, if you are, an example they use is, let's say you're driving down the road and 2 people on I-26 block you into one of those little blockades where you're 10 miles, you're tailgating this guy, you're honking, they're going 45 miles an hour and they're blocking the whole traffic. You're honking at them. You flip them off as you drive by, you point at them, say pull over. They pull over, they get out of the car with a gun and you shoot them. Well, again, you caused that. You're going to lose that one, you know, because you're the one that caused that to happen. But what we've seen unfortunately happen a couple times recently is, let's say you're driving down the road and you're a concealed weapons permit holder and somebody's got a flat tire or they're pulled over on the side of the road and look like they're disabled. You get out and it's a trick and they try to rob you. You can shoot them. You did not bring that on. You're defending yourself. I don't know if y'all saw those. That's happened twice in the state of South Carolina in the last, I think, 2 years, where somebody thought they were pulling over to help somebody and the people that are helping actually stole their car and robbed them. A case like that, you can 100%, you didn't bring it on. The force you were using was what you felt was necessary. They'll say there's 2 people. They'll say they have a weapon. Let's say, you know, they're actively telling you they're going to rob you. You don't have a duty to retreat. You know, you didn't have it. Even if you could have gotten back in your car and run, you don't have to. There are cases, though, where if you did retreat, you can't go back. Does that make sense?
Yeah.
So if you, go ahead.
So stand your ground, when I hear it, I think of it in context of firearms and deadly force, but it's just generally a self-defense, you know, doctrine?
Yes. I mean, you could have a knife, you could beat
It's
some,
just a
yeah.
matter of what is reasonable force used by you then, right? I mean, so
Right.
would the stand your ground doctrine kind of just be generally applied to self-defense in terms of
The stand your,
with a stick or something? You know?
stand your ground is only there because there are some states that have what they call a duty to retreat. We used to have that, which said, like, let's say you've got,
Is
yeah.
the duty in those other states, is it the duty to retreat from any violence, or does it have to be deadly violence?
Well, all it says is it's basically deadly or serious bodily injury. I mean, like if somebody's got a gun or if someone's attacking you with either deadly force or something that would cause serious bodily injury, in certain states, if you have the ability, like if you're standing there with a gun and I'm standing at that door, I got to run out that door if I can. Because I retreated. You know, let's say you dropped your gun and you're picking it up to come shoot me, and I see there's a door right there and I sprint out that door. Well, I've followed the law in that state, and it used to be the law here where I had to get out of here. But now, if you've got a gun and I'm standing there with that door open, and I'm just like, well, you know, in my mind I'm thinking, this guy could shoot me in the back, he could do anything. I don't have to run out that door.
Right, I understand that
Yeah,
the stand your ground eliminates the duty to retreat.
right.
But I only think of it in terms of, in the context of firearms. So if you were to hit me with a stick, and you weren't presenting deadly force or risk of great bodily injury or whatever, and I hit you back with a stick, right?
Right.
That's the force that I use in a situation like that. Is stand your ground a defense that is used outside of firearms?
You wouldn't even need it there. I mean, if you think about it, you're just defending yourself. I mean, stand your ground specifically for deadly force, and
that's what I'm asking,
it's. I mean, if somebody's beating you up and then you know, I always use the example. If somebody thinks they can kick your butt and then you tear them up after they hit you one time, you didn't have a duty to hit them one time and like go, okay, I'm done now. You know, that is kind of a stand your ground, but it's not literally under this. It doesn't say like you had a duty to do that. You're just defending yourself at that point.
Okay, I didn't know if it covered
Yeah.
itself.
No, it's specifically in the self-defense of like on the use of deadly force. It's specifically written for that. If you wanted to, you could probably use it, but you know, it's not necessary at that point, I guess you'd say.
Question, or to prevent the commission of a violent crime, I don't practice criminal law, would assault
No,
or
there's,
battery be a
if,
violent crime?
let's say you're in a gas station and somebody's holding a gun to the teller, and you're one of the people in there, and there's no cop in there. They have what they call the alter ego rule. Alter ego rule of the self-defense law is if that person has a legitimate claim under the self-defense, I think we're going to go into the alter ego rule later, but if that person has a legitimate claim under self-defense, you're defending, you're jumping into their shoes as their alter ego. You're preventing this violent crime from happening. It's not asking people to go out and become vigilantes and look for violent crime and then shoot people that are doing it, because, one example that we're given is, you walk up on a man holding a woman at gunpoint, and you think the woman's getting murdered or robbed or something, and you shoot the guy, and you look, and as she stands up, she's got a gun in this hand, and you realize she pulled the gun first. Well, you're going to jail. It's not a mistake, because if mistake was an argument, I thought she was being robbed, then we would have vigilante law everywhere. You have to be sure that that person needs defending under the rules of self-defense. That's that alter ego rule. And I think we'll go into that, but that's where prevention of a violent crime, if somebody's robbing you at gunpoint, it's armed robbery. They're not necessarily trying to kill you or kill the other person. They're just robbing you. So you prevented a violent crime by using your firearm to stop them and defending yourself. But you don't have to necessarily feel like, does that make sense? Okay.
I'm just wondering if the violent crime is something towards word, a battery.
No, well, in the state of South Carolina, violent crimes are considered, and there's an argument on that too, because drug trafficking is a violent crime, but you can't shoot somebody just because you know they're a drug trafficker. It's a crime of violence where the same thing would happen to somebody if it was like rape, for instance. To stop somebody from raping somebody, you can kill them or defend them in the alter ego rule. But that's a violent crime. But again, trafficking drugs is a violent crime. But unless you live in the Philippines, you can't go around shooting drug dealers. Apparently you can in the Philippines now, which I think is interesting. But
I think to answer his question, it's not the common sense definition of violent. There
Right.
actually is in the criminal code a laundry list of crimes
Right.
that are considered violent.
yeah, and I didn't happen to bring those. I appreciate that's there. Like I said, violent crime is there's in South Carolina we have violent crimes. We have violent most serious. We have violent serious. Assault and things that would not leave you dead are not considered a violent crime or a crime of violence. Castle Doctrine, it's an old law. It's always been around that says that your house is your home and you can protect it. It was codified, and we had the Protection of Persons and Property Act of 2009, which really clarified it. Again, the old law had, and we'll go through it in a minute, but the old law had the duty to retreat thrown in as the fourth phase, whereas under the Protection of Person and Properties, it's not in there anymore. Again, this says that a person's home is his castle and extends now to, this is another recent change from 2009, is it extends to your vehicle and your business. It used to just be your house, right? But it wasn't your car. You couldn't fire back, or you couldn't shoot at somebody that was trying to rob you of your car before. Like you couldn't kill a carjacker and say, I'm immune from prosecution. You'd have to go through the whole step of doing the self-defense argument. Now, as of 8 years ago, cars were included because, I don't know, there was a case in West Ashley, or James Island, in 2010, that this is the first time I saw this applied, where a guy was actually breaking into this guy's car, and the guy comes out of his house, and the guy happened to have a gun, and the guy that's coming out of his house just starts shooting at him and hits him in the head and doesn't kill him. But the guy was immune from prosecution based on the Castle Doctrine, according to the law there. Let's go on here. Okay.
Doesn't the good lot be occupied? We have to in it?
Not necessarily. That's what I'm saying. It is and it isn't. That one, they weren't occupied. It was just, the car was on his property, it was his car, and the person, he believed the person had a deadly weapon that was breaking into the car. And, I mean, again, if you practice criminal defense, you'll notice that these laws are not uniformly applied. I had a case in downtown Charleston where my client was a not very well off to do African American man renting a small little apartment, and a homeless guy comes up, asks him for a cigarette, and the guy had asked him for a cigarette 100 times before, and so he goes, yeah. When they walk in, well, my client got regular checks from the government and cashed them, and so he had a lot of cash in his house, and it was kind of known. Everybody, he had $200-300 at a time just sitting right there inside the door. Well, my guy goes and gets his pack of cigarettes and brings it out, and what the guy didn't know is my guy had been robbed before, and he had a gun in his robe pocket. He had a robe on with just slippers. Well, the guy jumps on his back when he goes in the door. He's still on his porch. So he jumps on his back while he's going to the door, and my guy pulls a gun and does this, deafens himself, but shoots the guy right here and kills him. Well, the police arrest him for murder. And I was a public defender at the time, and it took me almost standing on the police headquarters steps yelling at the officer to make them finally dismiss this case under Castle Doctrine. It happened to be a couple years before the new law came out, but they were trying to use the duty to retreat and saying that he could have gone inside, and I said, well, the guy's on his back. He said, well, how did he, they kept saying, well, how did he know he was going to try to kill him? I said, it doesn't matter. It's the threat of serious bodily injury inside your home. So that case got dismissed, but like I said, the guy had to go through losing his job for a murder charge. He had to go through not hiring a lawyer, but having me as a lawyer.
Lucky he had you as a lawyer.
Yeah, well, I like to think a lot of my clients say that, but.
Yeah, I know one of them does, yes.
But, so that one was a case where, it was kind of we'll arrest you now and we'll just shake it out and see what falls out, which, like I said, unfortunately, and one case that we'll go into in a few minutes, which is where the term comes from when you're doing a hearing to try to get these cases dismissed. I'll show you in a few minutes is after we get a little more into what the other parts of it are. And here it is. The second part is, against whom deadly force is used in the process of unlawfully or forcefully entering or has unlawfully or forcefully entered a dwelling, residence, or occupied vehicle. See, here's the occupied vehicle here. And like I said, I've seen it, literally 3 cases in this state where it wasn't an occupied vehicle. It was a person either near their vehicle was trying to be stolen, or they had just exited their vehicle. So if he removes or is attempted to remove a person against his will from the dwelling, residence, or occupied vehicle, again, that applies to carjacking, that applies to if you're trying to kidnap somebody, things like that. And who uses deadly force knows or has reason to believe that an unlawful and forcible entry or unlawful forcible act is occurring or has occurred, imputes with the legal presumption that the threat was deadly. So you're basically given if somebody comes in your house to commit a crime, kicks your door in, comes in, in a violent way, it's presumed that person's there to do you harm. You can impute that onto that situation. A time when you can't, an example is, in this book, is you've got an elderly, frail neighbor who has been telling you for years he wants your prized collection of silver dollars. And you leave, it's middle of the day, you come back, you see the doors open, you walk in and you see the man, he's so frail, he's just carrying the coins like this, he doesn't have a gun on him, and you shoot him in the back. It's not Castle Doctrine at that point, because what was your reason to believe that you were in fear of great bodily injury? A lot of people, you hear the stories about the corrupt sheriff's department in these small towns where they say, oh, well, just shoot him in the yard and pull him through the window. And I'm like, it doesn't automatically, you can't shoot somebody just for like climbing in your window. You have to have a little bit more belief. It's not just they're on my property, I can shoot them. Except for, and that's a good segue into State v. Duncan. State v. Duncan is where we get the term Duncan hearing. A Duncan hearing is a Castle Doctrine hearing that is done pre-trial. This gives you a determination of immunity pre-trial. That's why it's different than self-defense. The self-defense argument, you have to go through the trial and have a charge given by the judge that says the jury can consider self-defense. And one quick one going back on that, if you're ever trying a case and you're arguing self-defense and the jury and the judge tries to throw a mutual combat charge in there, then I'm talking about a specific judge, she has violated the law because mutual combat, if you don't do criminal defense, mutual combat means we both come up to each other, we're both yelling and cussing at each other, and we start fighting. That's a mutual combat. I didn't start it, you didn't start it, it just kind of started. Or you both had guns, you both start shooting at each other, nobody really knows where it started. That's mutual combat. But you can't put that in a self-defense case because what you're doing is you're telling the jury, if you think this person had no reason or nothing to cause this, then you can say this is self-defense. But then if you turn around and say, but there's also mutual combat. If you believe they have any reason of... Mutual combat basically puts not all but some of the culpability on both parties. If you argue mutual combat and self-defense in the same sentence, it's impossible because if you have any culpability in bringing on the event, then you can't use self-defense. And so it's really confusing to a jury because if you tell them, oh, well, if you think they had any part in it, it's mutual combat and they're guilty of this. Well, you've just kind of given them the answer. So, go ahead.
You know the case that says that jury instruction is improper to merge this together?
I was just in a PCR 2 weeks ago on it. I have it at my office. And the reason I know it's there is because I didn't argue it at my murder case I was doing. And the PCR lawyer brought up the fact, well, I didn't argue that case. I argued that you can't do it, but the judge allowed it anyway. And if you practice criminal law in this town, you know which judge it was. I'm not going to bring up names. So,
Did you win or did you lose?
no, I lost. That's why there's PCR. There's rarely a PCR when you win.
We just know it's there, thank you.
Yeah, it's there. There is a law, and it's fairly recent. It's not, like an 1855 law or something. Preponderance of the evidence is the standard on this. When you have a Duncan hearing, it's not as strict, obviously, as beyond reasonable doubt. It's preponderance of the evidence, which is the same thing they use in a civil case. It's now appealable after trial. This is a big thing because it used to be appealable after the ruling. Like you would argue it pre-trial, judge denies it, you immediately appeal it, and the trial doesn't start until that appeal is done. Well, now the courts have said, I think in 2013, the court said, yeah, it was 2013, the court said it's appealable after the trial. So you have to go through the trial, get convicted, and then appeal that you had the Castle Doctrine to be immune from prosecution. And it's worked because there was a Supreme Court case recently where they argued and won that, and they just reversed and dismissed the charge with prejudice because the immunity was there.
Except that the defendant has...
So the person did 6 years in jail, yeah.
Yeah.
Yeah, I mean, it's just, I know, I understand. Trust me, I understand. And the intent of this was to codify the common law Castle Doctrine, defining proper law-abiding citizens, protect themselves, families, and others from intruders and attackers without fear of prosecution and civil action. This is specific words from the Duncan case. This was because we had the common law. If you know the criminal laws in South Carolina, or any laws in South Carolina, you know that everybody used to use English common law, and Castle Doctrine goes back to that. We codified it in 2009, and that's what this specifically said, is this gives people now the ability to defend themselves without having to fear being prosecuted. Unfortunately, most of the times they are prosecuted.
Do you know which case resulted in this decision that was only appealable after trial?
The Supreme Court in 2013, I don't have the case on me. I have it on the next page, but it's not the case. I don't have the case. Person uses deadly force as permitted and is justified is immune from prosecution and civil action. So unless they use deadly force against a police officer. So you can't, if a cop kicks your door in, you can't use a Castle Doctrine when you shoot him because he's there serving a warrant or doing whatever. That's actually been argued, believe it or not.
Does he have to have
there's laws and rules on what they have to do. I mean, if a police officer's not wearing any kind of distinguishing clothing, they don't announce themselves, they don't knock and announce or whatever the things they're supposed to do. If somebody kicks your door in the middle of the night wearing a black T-shirt and brandishing a gun, nothing on it, that's their fault. That's not, you don't, you're still going to have to argue it because they're probably going to arrest you because you've just killed a police officer.
Right.
But you're going to make the argument and probably be successful because they didn't, that's why they, when you see these shows, they rip the thing off and it has police in big yellow letters, or they put a badge on or something. Dogging hearings prior to 13 were immediately appealable, therefore delayed in trial, and the Supreme Court ruled that it's now appealable after trial. And here we go. You do not have a duty to retreat. Again, this was the old common law said you did. It was the fourth section of it. Now it says you do not. The alter ego rule, this is the one I talked about earlier. This goes back to self-defense. If you're witnessing somebody being attacked or killed or whatever it may be, and you feel that that person was entitled to a self-defense, they could defend themselves, they hadn't brought it on. Again, you're assuming a lot when you become a vigilante because you're assuming that person had nothing to do with it. Because if you find out later, oh yeah, he had just hit me with a baseball bat or hit the person with a baseball bat and the person chased them down and was hitting them with the same baseball bat that they had just gotten and you kill that guy, well, this guy had originally hit him with a baseball bat, so he brought it on, so your alter ego defense is a loser. You actually become you'd probably get voluntary manslaughter. I don't think you're going to get murder. I think you'd probably end up with voluntary manslaughter doing about 20, which wouldn't be fun either way. All right, that's kind of where we end on the slide part. I wanted to leave intentionally about 30, 40 minutes to kind of go over recent cases. I don't have case sightings on some of these, but I have a case specifically that I'm working. That's the case I was telling you about where I got kind of attacked in the news for arguing. They said I argued stand your ground. I've said counsel doctrine in every interview I've ever done, but the national media picked it up as stand your ground, and it's the Loftus case up in Goose Creek, the guy that killed 2 people and buried them in the backyard and set them on fire. Remember that? Okay. That case is a case where it's 2 complete strangers. One of them's out on bond for attempted murder. He's a 4-time arrested. He's looking at life without parole if he gets convicted of this. There's a drug dealer in the car, and their cab, I guess what you call a gypsy cab, a cab that doesn't really have a meter. It just kind of goes to these places and picks people up and charges them $40 to take them home. Well, that case, the reason we're arguing counsel doctrine is the guy's being brought home by 2 people he doesn't know, one of them which is significantly larger than him. He goes in his home. The claim originally was that he didn't pay cab fare, and that's an argument you could make on did you bring this on yourself. The argument I've made on that, which I made to the judge originally, was not paying cab fare is not a reason that somebody can kick your door in. You understand? Like it has to be reasonable. Like for instance, if you had just hit somebody with a bat, let's say, and you run inside your house and they're chasing you and they kick your door in and you shoot them, well, chances are you're not going to be able to use counsel doctrine because you retreated to your home, and yes, they should have called the cops, but you're not without fault in that case. Is not paying somebody a cab fare reason to be killed or reason for somebody to break into your home? It's a question we're asking. Also, and the reason this one comes up with the counsel doctrine and why it's gotten so much attention is because of what they did afterwards. What the person did after when you dispose of bodies by burning them. They're implying malice through the burning of bodies. And I apologize if this is offensive to anybody about talking about people getting killed, but the argument we made was, at what point, when somebody's kicking your door in, and they're kicking it so hard that it's breaking it off the hinge, breaking it off the frame, and even if you let them in, let's say you know they're going to get in, the door's breached to this point, and you just say, you know what, I'm going to let them in and try to, whatever, I'm going to try to reason with them. Have they unlawfully entered or tried to enter your home? Even if you let them in, I mean, or were they trying to get bodily injury on you? If they come in at that point, and this is another one, is I'll go back to Duncan in a minute and tell you the facts of Duncan, and you'll understand what I'm talking about. If somebody threatens you when you're in your house, like let's say they're an invitee and they become, say I'm going to kill you, pull a gun on you. This is a big question we had about 4 years ago. And it's in the, if you can look up these articles in the paper, our solicitor here, one of the solicitors here, argued that domestic violence people are not allowed under the Castle Doctrine to defend themselves against a person that lives in their home. And the Judge Nicholson basically said, well, that's silly, because now you're just basically saying you can only, if the person that lives with you is trying to kill you, you can't defend yourself. But if a person that comes in off the street, you can, because I don't know if you've read the stats, but we're one of the highest death rates for domestic violence in the country. But there were 3 cases overturned, the Supreme Court overturned 3 cases in South Carolina where Castle Doctrine was used, but denied, where the women were being beaten, being, tortured by their husbands. One woman went out to the garage and came back in, and the guy came at her, and she had gotten a knife when she went in the garage. And they said, well, you armed yourself when you went in the garage, so you came back in and it was your intent to kill the guy. Well, she said, no, I did that because he had just punched me like 10 times, and I was coming back in to get my keys so I could take my car. And the guy attacked me again. They said, well, but you armed yourself. So Castle Doctrine doesn't apply because you left the threat and then went back to the threat. Well, if you ever know anybody that's been the victim of domestic violence, going back to the threat sometimes is the only option you have, because it's either that or go just outside, because you may have a person that doesn't give you the car, or doesn't give you anything, but going back in the house may be the only way you see to do it. I mean, this battered woman syndrome is a legitimate condition. It's not something that's just made up by, prosecutors and defense lawyers. But those 3 cases were all overturned under the new Castle Doctrine rules. It took them, again, 6 years to do it, but all 3 women have now been exonerated.
And that was on, I don't think it's in Charleston.
I'm sorry?
Those 3 cases were in Charleston?
No. One was in Columbia. I want to say one of them was in Greenville. I don't know what the other one. Greenville's got 3 of the biggest Castle Doctrine cases. For some reason, it's very popular to defend your home in Greenville, South Carolina. I don't know why.
Isn't there a case out there that says once there's a break in a chain of events, okay, so we have the example, and I think I remember right about not paying the taxi and then running, and the taxi got chased, right?
Right.
Isn't there a case out there at some point when you retreat from the situation,
Mhm.
there's a break, and then that new aggression by the person at that point, you
Right.
can use castle?
Right.
But I'm maybe misheard. you.
That's the argument I make.
You said
That's,
that you couldn't do that, and I thought that there's a case out there that says if there's a break, you still can
Right.
preserve that if the break is sufficiently recognized by the court or the jury.
right. Is when you can't use it is when the break is you got away and they went away. You can't take a break, go arm yourself, go inside, and kill the person that's in your house. If you get out and run, you got to stay gone. You can't go out, get your gun out of your car and go, all right, now it's a fair fight. Let's go back inside, because at that point it's just,
But
I mean-
if your children were in the house,
yeah, you're okay then, because you're defending your home and your children from this intruder. I mean, if the guy had your kids had the door locked and the guy's banging on your kid's door, you're protecting the children. You're not, but if you're the only person there and you go outside and you go to the car and you get your pistol out of the car and come back inside, then what they're going to say is you had a chance to leave and you had a chance to call the police. So, because what you're doing then is just protecting your property, which is not the intention. Duncan was an interesting case, and Duncan is, in my opinion, one of the more cloudy cases of castle doctrine. It's Duncan, and there's a guy named Spicer that was coming in. The reason I think it's ironic is because of Sean Spicer now, the new. But Spicer and his girlfriend come over to Duncan's house, and Duncan is showing pictures of his family and things like this, and there's a picture of his daughter in a cheerleading outfit. And Spicer makes an extremely inappropriate comment. Duncan tells him, "Get the hell out of my house. I don't want you in here." And Spicer and his girlfriend leave. And then Spicer's been drinking, so he gets pissed off and comes back on and starts banging on the door on the porch and says, cuss words, whatever, "Screw you, I'm coming back inside." Pushes the door. Duncan pushes back. He pushes. Duncan pulls a gun. He keeps pushing, and he shoots him and kills him. And they said that forcing his way back in was enough to say that's the threat of serious bodily injury or death. Even though this guy's been in his house, he was a guest, he didn't show any proof that, hey, I've got a gun on me in my pocket. He did go back out to his car, so we don't know. I think the argument was that he may have been armed or he may have armed himself. But, Duncan is the kind of golden rule case. And in my opinion, it's one of the cloudier cases because the guy left your house and he's coming onto your porch. And then another Greenville case that happened in the last 2 or 3 years. Again, I don't know the name of that one. I should have brought these, but he was like the heir to some, or maybe he's a microbrew guy that owns one of the bigger microbrews. There's something big about him in Greenville. And he's got a huge property with about a quarter mile or 3/4 mile driveway. And a guy's walking up his driveway on his private property. And he's yelling at him, saying, "Leave my property, get out of here, you don't have any right being here." The guy keeps walking. He says, "Get the hell out of here." And he fires a warning shot with a shotgun. And the guy keeps coming. And he shoots and kills him. And he was immune from prosecution under the castle doctrine.
On the land?
Yeah. I mean, the guy was,
You don't have to be in the structure.
it's not inside your structure. I mean, if you,
I think it depends on the judges. I had a case where, and I don't mean to finish, this is exactly, it's so contradictory to what you're saying, and I'm so frustrated because to this day, it's been years, to this day, this case eats me alive. I had a 15-year-old girl, tiny little girl, who had a fender bender with a man who was a giant bodybuilder prison guard. She was scared. He got out of the car and started screaming at her. She was scared, took off. Left the scene. He chased her all over Myrtle Beach, finally tracked her down. She thought she was going to a parking garage, went down into a loading dock. He tracked her in there with her car, jumped out of his car, started running to her car, jumped on the hood, started screaming, tried to reach inside the vehicle. And she drove off. He slid off the hood, knocked his head, and had brain damage. They accused her of attempted murder. I argued, number one, they argued, I know. And so, the judge said, number one, she was at fault with the fender bender. I argued the break-in circumstances when she left the scene,
Yeah.
the county chased her, right? Didn't fly. I also argued Castle. This is pre-trial. I argued Castle, saying that he was physically larger than her, trapped her in this loading dock. There's a wall.
Yeah.
And how he physically jumped on the car and tried to reach around screaming and yelling at her, and the size difference and everything. And the judge says Castle doesn't apply here because her fault. She initiated the whole thing. And number two, because he physically didn't actually enter the car. Therefore, it doesn't apply here. She's in prison. She would not let me take this to trial and at least attempt to argue self-defense on a secondary level.
Right.
At least let me argue self-defense. She wouldn't let me do it. So this little 15-year-old was down to serving 6 years because the judge made these rulings. And I think it's so arbitrary and it's so frustrating to see all these cases that people are doing.
Yeah.
And then I see this guy shooting somebody in the driveway, and I'm going, are you kidding?
But
Yeah.
isn't it
And
the
then I've got my
prosecutor
girl.
who made that initial decision to prosecute
Of
them?
course,
Yeah.
of course.
And where was this case from?
Ori wasn't tried.
I mean-
Yeah.
Was-
Ori, in Myrtle Beach.
She pled to active time on that case?
Yes, sir. I tried. I did everything I could, and she finally said, I don't want to do this again. And to this day, it eats me alive because it's so wrong.
I thought my case of murder that just got PCR'd ate me alive. That one, I'd quit practicing law if that was my case.
I am very
I would lose faith in
I hear
the-
this guy in the driveway getting shot, and I'm going, are you kidding?
Yeah. Well, did they appeal the castle doctrine denial?
She won appeal, she wouldn't go to trial, she wouldn't do anything, she ended it there and went to prison. Refused, the family refused, she refused to do anything as far as post, anything.
The Supreme Court would have reversed that on on the denial of the castle doctrine.
Sure sounds like it.
In a
Yeah.
second, so it's frustrating because
Well, like I said,
it's so like very.
the problem is it's not it's a gray area. It's not a black and white. I mean, it's up to the person you're arguing it in front of that day whether they think a reasonable person would have thought that.
So in that situation, being 15, I don't practice criminal law at all. Do you get a guardian, or can you file a motion, get a guardian appointed that's just not making a good decision for herself?
Well, her mom was there the whole
Yeah, Mama.
I'm
Yeah, I don't know.
Guardian ad litem, because obviously mom's not making it. If you bring in another
Yeah.
counsel, I would already have to judge.
That'd be odd. Oof. That's the worst one I've ever heard, by the way.
I did everything I could, but I couldn't make her agree or have her, I couldn't talk her into anything. And I didn't know, maybe, I'd like to do something today to help her, but.
Yeah.
You know, it's frustrating.
The one you were talking about.
Wait, I'm sorry.
It's been a long time since law school, but they used to talk about, when I used to deadly force, whether it was within the curtilage. Is that term used anymore? Like,
Yeah, I mean, that's what I'm talking about.
Case, was it within
Yeah.
something that he considered his
Right,
domain?
and the argument is, yeah, the curtilage, within close proximity, I mean, the curtilage comes into play, again, that's a law school term that doesn't get used, I don't think anywhere else on the planet, but, they argue that when I had a burglary case where a guy broke into a garage that was used to store supplies, and they said it was the dwelling, so it was burglary first. We got it dismissed, but it was, because it was within 200 feet of the house, and because people would go in there. Even though it was used for supplies, people would occasionally go into this garage. So it was considered part of the dwelling. But I think, again, it's a case-by-case basis. And I think if you make the argument that, okay, so at what point does that threat become real? In your mind, in a reasonable person's mind. If a person is coming at you and you're telling them stop, you fire a gun, they don't stop. First thought I think, if I fire a warning shot at somebody and they don't stop, my first thing is, okay, this guy's crazy or this guy's trying to kill me because I just shot at him and he's still coming, Terminator style. I mean, I don't know, I hadn't looked at the facts of it, but I did read about it. And I know that, I mean, I'm sure the guy has millions of dollars. Like I said, it's a high profile guy. I can't remember his name. But he's like either the heir of a beer fortune or he runs some big brewery or something like that. But it happened like 3 years ago in Greenville, another Greenville case.
That's a scary place. I don't think I want to go there.
I love Greenville. Apparently there's a lot of break-ins in Greenville.
It was in that case I was going to ask, wasn't that prosecutorial discretion? I mean, I don't think it got adjudicated on Castle.
Right, no, that one didn't get adjudicated. That was prosecutorial discretion. Again, and that's something where, because that might not have applied. So that may be what the kind of the difference we're going at here. Castle Doctrine, I think, would have lost in that argument because I think that, 50 feet away, go in and lock your door. But then the argument is, well, he didn't have a duty to retreat. He's on his porch. He's in the quiet enjoyment of his home, which is another legal term we love to use, the quiet enjoyment, and somebody's coming up on his property. So you don't know that person, and at that point that person was well over half a mile onto his property. It wasn't like he was just, you're out on the outskirts and you hit the no trespass sign and jumped the fence and I killed you. I think it was a little more serious than that. Like I said, I don't know every fact of that case, but it was a prosecutorial decision. So, what other questions do we have? Examples, questions, anything? I like that example, except that I don't like the result.
I'm still struggling to this day.
I,
I'm ruined.
yeah, that one would haunt me. I can understand why it would haunt you. As a defense lawyer, that one would eat me alive.
I'm ruined. I got
Okay.
You've been very helpful on concealed weapons and pistols and all that, and you mentioned earlier that for long guns it's different. What, just kind of in a nutshell, are the rules on long guns in South Carolina?
Long guns, I want to say you can be 18 to buy them as opposed to 21. The waiting period's shorter on the federal list for long guns. I want to say the waiting period on some of them is 0. Because I know it's easier to get an AR-15 than it is a pistol. Because an AR-15 is a long gun. No, you can't. I mean, does anybody know that one? I don't really know that one as well. About hunting, fishing thing, I know is an exception, but I don't think you can't walk around with an AR here like you can in some states. Because I know, like I said, you'll see the protest. You can always tell when it's an open carry state, 'cause you'll see the protest. They'll have it strapped on their back, or they'll have that police thing right here where it's just sitting like this so they can easily turn it and shoot it. Like the vest with the hinge here. But that's, because you always see the Facebook picture where it's like, how is this legal and this is not? And it shows people protesting, getting tear gassed, and these guys have ARs. Sorry.
I've looked for it and I can't find a law that would stop me from carrying my shotgun into the mall.
Yeah, that's what I'm saying. Long guns are just,
Inciting a riot or, disorderly conduct. stuff
Yeah.
like that, but not as gun-specific law.
yeah, I don't think there is, like I said, long guns just have, because we're a hunting state, long guns are like, the golden goose. They're not going to do anything to stop you from having a rifle or a shotgun in South Carolina, because then the Ducks Unlimited guys and the NRA and everybody would,
And then carrying in the car, does it have to be in the case? How you lock it, does it have to be in the?
No, long guns don't, again, long guns don't, the
Doesn't
same.
have to be case, and you can carry it anywhere in the car, but if it's loaded on a street, you have to have written permission to hunt the property adjacent to the road you're on.
Right, yeah, I know there's an adjacent property rule. That goes to hunting things, because,
It's just whether it's loaded or not. If
Right.
it's unloaded, there are no
Right.
case or carry requirements out there.
I need
Do
to-
you see these things in the gun racks that are unloaded?
I think they have to.
more, yeah, if it's, carrying a loaded gun in your cars, then there's some pretty strict rules on that. I mean,
Not for handguns.
Right.
Handguns, there's no problem.
Right.
You can keep them loaded up.
right, you can keep it as long as you keep it in the right place. But if you have a loaded gun on the floorboard of your car, you're going to jail that day.
Unless you have a concealed carry.
No, it still has to be in a certain spot. You can't just have it anywhere.
Okay.
You have to have it on you or, next to you or something like that. You can't have it like underneath seats. I mean, there's,
I think the difference is the permit holder can have it in unenclosed compartment.
right,
In the basket compartment.
right.
So it can be in a
Right, you could have it like, where the popular place to have guns with my clients that have the illegal guns is under the front seat or in that side little thing here. You can have it in that side compartment if you have a concealed weapons permit. But like I said, that's why when the police pull up, you go, here's my license, and the gun's right here. You don't pick up the gun, you just say the gun's right here or the gun's over here. You pick up the gun, you get a gun drawn on you, more than likely. So, but any other questions? I'm a little short of my 2 hours today. Trying to think. Oh, I know what I'll talk about. If you practice gun law at all, South Carolina gun law, there's a new edition, comes out every year. It's done by Stephen Fulton Shaw. This is pretty much every answer to every question you've had today. I probably could have found certain answers in here, but I just didn't feel like, thumbing through the book while I was trying to talk. But the case is, if you want to write a case down, trying to find that other, I can't remember which one it was, but the Duncan case is State v. Duncan. There's also State v. Manning, State v. Curry, and State v. Isaac. Those are four Castle Doctrine cases that are really going to lay out, what you can and can't do, the way the court views it, and things like that. So, and again, I would suggest. Oh, and you were asking about that list of violent crimes. The crimes that you can assume are going to happen, felonies that you can protect from. Remember, you were asking which crimes. It's murder, first and second degree criminal sexual assault, which is rape, first and second degree criminal sexual conduct with a minor, first and second degree assault with intent to commit criminal sexual assault, assault and battery with intent to kill, which is deadly threat or use of deadly force, kidnapping, voluntary manslaughter, armed robbery, attempted armed robbery, carjacking. And see, here's drug trafficking, which, again, That's the one that's gray area. It's a violent crime in the state of South Carolina, but the violence is defined by a conservative legislator, which is you're killing people with your drugs. So if you made that argument at court, well, he was slowly killing my town, I think you might lose. First and second degree arson, first and second degree burglary, engaging a child for sexual performance, homicide by child abuse, criminal domestic violence, high and aggravated nature, abuse or neglect of a vulnerable adult resulting in death, and accessory before the fact to commit any of the above offenses. That's the list that South Carolina considers violent crimes. So the only one on there that I would, like I said, that's the gray area is drug trafficking. And because I think we're one of the only states that considers drug trafficking a violent felony.
Well, but that list compared with her case, and it's a terrible case of a 15-year-old, if you can use deadly force on a carjacking, the classic carjackings, they come up at the stop
Right.
sign, they put a gun at you, and they say, get out of the car, so at that point, you'd be entitled to use deadly force.
Right.
Shoot them, but that judge said no, or the prosecutor said he has to be in the car. At that point, there'd be no way to do the.
Well, you don't, because you don't even have to be in the house. If you're kicking the door in, I can shoot through the door.
No, but I mean in a car.
Right. Well, but I'm saying if you're banging on my front windshield
Yeah.
and you're swinging through and trying to get me with something, I can shoot through the windshield.
See?
There was something else going on with that, too. I don't know,
There's
should
a
have been.
brand new prosecutor, and they're trying to show, prove themselves.
Well, and also, the issue I'm running into with that one is to say that getting in a car accident is causing the altercation is just stupid.
It wasn't without fault, and there
Oh.
was a literal reading of the statute that said
That's
she
as-
was at fault with the fender bender.
That's as liberal as you can get. Because you could say, you know, if you want to start doing that, you know, you could say, oh, he's a Donald Trump supporter and he pissed him off, so he wasn't able to kill him after the guy pulled a gun on him or something like that. I mean,
The
that,
judge was
Road rage.
extremely old, and extremely,
I wish they would have appealed that, because that would have, I'll guarantee, I mean, on an appeal, I think they would have won on that castle doctrine argument.
how can I appeal the client is not interested?
I understand. I mean, if they're,
So that's why, I don't mean that to be argumentative, but.
no,
how can I help?
I'm saying I wish they would have. It would have been,
How long has she been with Reverend?
I think it's been 3 years now.
good Lord.
So she's still underage?
She turned 16 at the time. She was,
Why they try as an adult?
you tell me, it was all this, the list just continues.
And I got two places I'm never going,
Because she.
Myrtle Beach and Florence.
On a permit driver, on a licensed driver, this goes on and on and on. This is disturbing.
That is, well, like I said, for every Duncan case where it looks like they shouldn't get away with it, there's one or two of those where somebody gets, you know, bad prosecutor, bad judge, bad jury, and all of a sudden,
And I just hate it for her, because you can't put a kid that young in jail and not be ruined, even if she got out now.
Yeah.
She's seen so much.
Because she went to adult jail, yeah? She didn't go to juvenile.
Oh, they sent her, who did they send her to juvenile? You can't send a 15-year-old to an adult prison.
well, juvie, she can only stay
Well,
there.
she was 16 at the time, of course.
Well, yeah, she could do 6 years. So they sent her so she was 21.
No, they sent her, they tried her as an adult, they sent her to juvenile until she turned 18 and they transferred to an adult.
Oh, my God.
That was my
Good
understanding
Lord.
of how that.
Just keep on coming.
I know. So, I mean.
Well, what was it, an 85%? Was it an 85% crime?
Attempted murder.
Yeah, so she does 85% of that.
I couldn't even get her to sentence her under the Youthful Offender Act.
Yeah. Remind me who that prosecutor is?
Richardson,
Richardson? Okay.
sorts,
Just remind myself not to practice in Myrtle Beach under Richardson. Richardson's got the case.
He's the only girl, well, no, there are Richardsons. There are only
A female did that to a female girl? Female prosecutor?
four. Yes. This is my cue to not say anything.
Okay.
Yeah.
Just shocked. It's
Just
just-
because someone's female does not mean they're progressive, kind, compassionate.
I understand that. I understand that, but I don't know. A 15-year-old girl just seems a little bit, you know. Did the guy have a record?
He was a prison guard. He was massive and
Member of
in
the club.
size. And,
So he's a sheriff's deputy.
I'm not sure of his certifications. I just know he was massive in size and this is what he done. He
You sure this wasn't Florence?
Sorry.
Sounds a lot like Florence.
Oh, God, it's another place down there.
Uh,
So,
Okay.
I just wish I could do something, I just.
Well,
Well, you can't do for a client what you don't let you do, so.
Gosh, don't we wish this is a case we could really fix?
well, again, if you're interested, like I said, Stephen Shaw is the author. You know, they do a gun, I won't talk about what they do, but they do a lot of stuff on guns. So, but this is kind of like the Bible for South Carolina gun law. It's got answer to every question, examples, cases. So it's a really good book to have if you are practicing criminal defense, especially with guns. So, any other questions? I hope you learned something at least. Okay. Well, that's, at least if one person says yes, then I guess I did my job. All right. Well, I let go a little early, so is that okay? Just a little bit? All right.